Good morning. We will start the Asm Judiciary Committee for Tuesday, June 30th. We will start as a subcommittee. Our first author is Senator Monning. Item number 2, SB 253. And just for the file, item number 7, SB 582, Mr. Hall, and item number 6, SB 501, Mr. Wachowski, have both been pulled from the agenda. Senator.
Good morning, Mr. Chair and members. First, I'd like to begin by accepting the mock-up amendments that you've been provided with. SB 253 strengthens the juvenile court process for authorizing psychotropic medication use by foster children. This bill mandates the application of health care standards by the judiciary when authorizing psychotropic drugs to children in foster care. No psychotropic drugs would be authorized without prior medical exams of the children, and ongoing monitoring must occur. For treatments with the greatest risk, a second opinion from a psychiatrist must be obtained. The data is very troubling. Nearly 1 in 4 foster youth receive powerful psychotropic drugs. Of all the children taking psychotropic medications in California, 52% are given antipsychotics, which have risk factors that can lead to lifelong disabilities such as tremors, obesity, and diabetes. 48% of foster youth are given antidepressants that have an FDA black box label warning for use by children. We, the state of California, assume the role of the parent for foster youth. It is the job of the legislature to address this problem for a voice that doesn't often get heard. I respectfully ask for an aye vote, and I have several witnesses here in support. Through the chair, if we might present our witnesses in support. Thank you.
Please do. First witness, please.
Chairman Stone and members of the committee, my name is William Grimm. I'm senior attorney at the National Center for Youth Law, where for 25 years I've led our firm's practice around the reform of child welfare systems throughout the country. I'm also a member of the expert panel of the state's Quality Improvement Program on psychotropic medications for children and youth in foster care. And I and my colleagues have been a member of all 3 work groups of that Psychotropic Med Quality Improvement Project. SB 253 addresses a crisis in our foster care system. Too many foster children receiving too many psychotropic medications, oftentimes for too long, at dosages that are too high and with too little oversight. Our laws acknowledge that the administration of psychotropic medication is outside the realm of normal routine medical care. These medications, many of them not FDA approved for children, prescribed off-label, often come with severe adverse effects. For children and adolescents whose brains are still maturing and developing, these drugs can have profound short and long-term effects. When it comes to psychotropic medications, children are not little adults, and their reactions to these powerful drugs are often more pronounced and severe than adults. Existing law, Welfare and Institutions Code, Section 369.5, includes a single sentence listing a few things the court should consider before authorizing these powerful medications. Under the current code, the court may authorize medication on the basis of a single physician's statement. It does not have to be a psychiatrist. Even our prisoners and sexually violent predators under the penal code are entitled to the recommendation and evaluation of a psychiatrist before they are subject to involuntary or medication. SB 253, as Senator Monning has pointed out, creates a more rigorous process commensurate with the seriousness of the decision to administer psychotropic medications to a child or youth. It ensures the court is provided with the nature and extent of information that the adolescent and child psychiatry associations themselves use as the standard of care. It establishes criteria for the court's decision and requires a timely review of the child's response to the medication. And for prescribing that the psychiatrists themselves, again, regard as the riskiest practices, it provides for the court to have the assistance of a second opinion. As Judge Nash, the former presiding juvenile court judge in Los Angeles County, testified several months ago, These are the things that a prudent, responsible parent would do for their own child. Foster children for whom the state or county is the guardian are entitled to the same level of protection. SB 253 addresses the very health and safety of our foster children, is a critical piece of a multifaceted set of improvements in the decision-making and oversight process, and we urge your strong support for the bill. Thank you.
Thank you. Before we go to the next witness, I'd like to establish a quorum.
Stone.
Here.
Wagner.
Here.
Alejo. Chow.
Here.
Chu.
Here.
Gallagher.
Here.
Garcia. Holden. Mainshine.
Here.
O'Donnell.
Here. We do have a quorum. All right, your next witness, please.
Yes, thank you.
Hello, my name is Tisha Ortiz, and I'm a former foster youth. I was in foster care from 4 to 8 years old. I also re-entered when I was 12. I re-entered the foster care system with severe PTSD. When I was placed in a group home at 14 years old, I was forced to take 12 pills a day, 6 in the morning and 6 at night. I suffered side effects from these medications that I still see today. I gained a lot of weight, and I still can't lose it. I have an irregular heartbeat, and I suffer from facial tics from time to time. These medications weren't used as a treatment for some supposed disorder I had, but as a way to chemically restrain certain behaviors that are very common in the group home setting. If a judge reviewed my case accurately, he would have noticed the strong doses I was being given and could have put a stop to the negligent practice of over-medicating foster youth. If this bill were enacted when I was in care, I would also have been able to agree or disagree to the treatment I was being given. I would have been able to have a hearing so I could object to some or all of the medication I was taking. A judge could have made sure that I was receiving therapeutic behavioral services, which is a less invasive treatment that had actually helped me, instead of using powerful chemicals that were doing more harm than good. I didn't receive these services until I was almost 18, about to age out of the system. I should have been receiving them before I was given a dangerous cocktail of psychotropic medications. Giving a child a voice in foster care, whether or not can help curb the mistreatment of foster youth through the use of medication. Stories like mine are common in the foster care system, and I strongly urge you to vote yes for SB 253 so foster youth get the help that they deserve.
Thank you. Next witness, please.
Thank you, Mr. Chair and members. Kathy Sunderling McDonald with the County Welfare Directors Association in support of the bill. I think there's little to add from the prior two speakers, just to say that we do believe that medications can be appropriately used for children in foster care, but they must be thoughtfully prescribed, and they need to be part of an overall behavioral health treatment plan, as you heard from the previous witness. There are other types of services that can be just as effective, if not more effective, than a mere medication or a medication on its own. So for those reasons, we did work very closely with the author and with the sponsors to work on some amendments while the bill was in the first house that enable us to support the bill as we do now. And we do think the current version strikes an important balance between the ability of children to receive these medications when appropriate, with appropriate oversight, and also the need to ensure that we're not over-medicating children or using it inappropriately. Thank you for your support.
Thank you. Any other testimony in support? If you could give your name, your affiliation.
Nicole Wortelman on behalf of the Alameda County Board of Supervisors, also in support.
Thank you. Anyone else in support?
California, in full support. We appreciate the amendments that the author has made that addressed our initial concerns while in the first house regarding the age of consent to be lowered to the age of 12, which is consistent with many other areas of the law where adolescents are able to consent to sexual reproductive health treatments and things along those lines. And then obviously the second portion of that is giving them the ability to refuse, as the witness has pointed out. That would have been important. So
thank you. Anyone else in support? Is there anyone in opposition?
My name is Rochelle Trottenberg, and I'm a former foster youth, and I support this bill.
Thank you. Opposition, please.
Thank you, Mr. Chair and members. Christopher Castrillo here on behalf of the California Academy of Child and Adolescent Psychiatry. Not here in opposition to the bill. Do have some outstanding concerns based on after the most recent amendments. Before I do that, I just want to thank Senator Monning, his staff, National Center for Youth Law. We've been working together very closely over the last couple weeks. Definitely want to recognize the age 14 informed consent amendment. That was a very significant concern on our behalf, and we certainly appreciate them taking that. With that said, we are still intending to work with the sponsors and the senator on a specific piece of the bill regarding the delivery of information for that a prescribing physician must review. We are working to try to ensure that there's a single point of contact for a prescribing physician to have the healthcare information history, the contact information for the individuals that they're supposed to discuss and meet with under the provisions of this bill. I have here Dr. Forrest if you have any technical questions. And again, we look forward to continuing these conversations and working these out before our next committee hearing in Human Services.
Thank you. Next witness, please.
Good morning. Adrienne Shilton with the County Behavioral Health Directors Association. We represent the public behavioral health authorities and counties throughout the state. We're not here in opposition. We're here with a couple of outstanding concerns and join our colleagues here. We've been working together quite closely with the bill sponsors and the author, and we thank them for the most recent amendments. We are supportive of those, but we do have outstanding concerns, particularly around the second opinion and also around the information that Chris provided about the healthcare history language. We certainly support the intent of this bill to support the rights of foster youth from inappropriate medications, but we don't want to be throwing up additional barriers to care. And we think that that language around the second opinion is going to particularly affect the most rural in counties of the state where there are no child and adolescent psychiatrists. So we look forward to continuing these conversations with the author and the sponsors as this moves forward. Thank you.
Thank you. Anyone else in opposition? All right, seeing none, I'll bring it back to the committee. Questions, comments from committees? Mr. Chu.
Thank you, Mr. Chair. First of all, I want to thank the good senator from Carmel for moving forward AB 253. I'm proud to be a principal co-author on this measure. Colleagues, if you have not had a chance to read any of the recent and incredibly troubling reports of the over-medication of young people in our foster care system, I encourage you to do so. We know that nearly 10,000 California foster care youth have been prescribed psychotropic medications, some of them for more than one drug at a time. And the reports are incredibly alarming. The increase in the use of psychotropic medications have been incredibly alarming, and we need to have clear standards. I think this bill very clearly and understandably establishes a good standard when it comes to our courts, and it is part of a broader package that is moving its way here through this body. When I first came into office, I was looking at a number of policies that we could look at in this area, and I was pleased to learn that 4 senators have moved forward a package that we'll be considering along with Senator Mitchell's bill at item 2. And with that, I very much hope that we can support the entire package, and I'm happy to ask that we move this forward out of this committee.
Is that a motion?
That is a motion.
That is all. I'll take a motion. Is there a second?
Second.
We do have a motion. Any second? Any other? Mr. Gallagher?
Yeah, Senator, I agree with what you're trying to do here and the motivation behind it. But I know there are some some suggested amendments that, that some of the opposition has proposed, such as, in making the court order that, that there is a less invasive treatment, that be based on, medical experts, and that be based on expert testimony. Also, there's issues with sometimes these medical records aren't available. So in doing the comprehensive review, which I think should happen, they may not have access to all those records. And so there's some suggested amendments on dealing with those issues. And they also noted that there's some issues with what would a second opinion, what would qualify as a second opinion, and maybe not allowing a second opinion to come from someone who hasn't had, real access with that young person. and is not familiar with their history and hasn't been caring for them in any way, that perhaps that's not the best second opinion out there. So, I mean, just in some of those issues, could you address them? I think
Sure.
we're all going to be supportive of what you're trying to do, but I think there's some
Great.
things that could make this better.
Great. Well, I appreciate your question and highlighting those concerns. I think before you arrived, I did accept the amendments that you have in the mock-up, and yet there are still issues outstanding, some of which you highlighted, that we're absolutely committed to working on as this bill moves forward. We have a shared objective in getting it right, and we have a shared objective in protecting children from being really guinea pigs in massive medication that in many cases is used because there aren't sufficient resources for real therapeutic engagement. And from some of the other foster youth that we've heard from, they've been disciplined in group homes when they've requested access to a physician to review their medications because of the side effects, and they're penalized for making that complaint. And so they're locked into this system. And then we see these success stories of foster youth who have connected with a therapist who's weaned them off the psychotropics and gotten to the heart of what's often post-traumatic stress syndrome from really tough childhoods, where they get to the bottom of that, and for the first time somebody's taken an interest in that person. But without going into all those details, some of these fine points, the rural areas issue, where do you find that second opinion? Absolutely agree. You've got to have access to medical records. Hopefully with our evolving electronic medical record system, we're going to be better able in time to have more instant transmittal of medical records. When there is a psychiatric evaluation, there's even greater protections under HIPAA, and so some challenges probably in the transference of medical records. So, but it's all on our radar. We're committed to working on it. We're not seeking to avoid any of those important issues, but I appreciate your highlighting them. Thank you.
Senator, I want to thank you for bringing this forward. I think too often our systems are really more for the benefit of the system rather than the person the system's charged to take care of. And in the chemical restraints area, that's fairly clear. There's enough evidence that the chemical restraints are used more for the convenience of others rather than a close look at what that child actually needs. And without the review of the record, without a real in-depth look at justifying the need for the psychotropic medications, they can be used as a bit of just more for the ease of the folks around that child. And I think what your bill does, and the package of bills that's coming to us, is shift those presumptions to really look at whether or not that medication is necessary for a benefit to that child. And I appreciate that you brought this forward.
Thank you. And just a final comment, and it's in the mock-up. We also have provisions where, under emergency circumstances, where the health or safety of the child or other children is at risk, there are provisions that allow for the more immediate prescription of those. But again, we want to make sure that there's multiple pairs of eyes that are first and foremost watching out for the interest of that child. I also just want to thank the principal co-author, Assemblymember Chu, for his support, and I'll use that as my close and respectfully ask for an aye vote. Thank you.
Thank you, Senator. All right. The motion is due pass as amended to Human Services. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo?
Aye.
Alejo, aye. Chow?
Aye.
Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
Aye.
Gallagher, aye. Garcia?
Aye.
Garcia, aye. Holden?
Aye.
Holden, aye. Mainshine? Mainshine, aye. O'Donnell?
Aye.
O'Donnell, aye.
Your bill is out.
Thank you, Mr. Chair. Thank you, members.
Thank you. And we do have two items on the consent agenda. Unless anyone would like to remove an item from consent, I'll take a motion. So moved. So we do have a motion and multiple seconds. That's great. On the consent agenda, so you call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo?
Aye.
Alejo, aye. Chow?
Aye.
Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
Aye.
Gallagher, aye. Garcia?
Aye.
Garcia, aye. Holden?
Aye.
Holden, aye. Mainshine?
Aye.
Mainshine, aye. O'Donnell?
Aye.
O'Donnell, aye.
Thank you. Those two bills are out. That is SB 646, Senator Jackson, and SB 738, Senator Huff. That now brings us to item number 5, SB 308. Senator Wachowski.
Good morning, Mr. Chair and members of the Assembly Judiciary Committee. SB 308 is a bill that will make long-needed, meaningful updates to California's exemption laws. In my 28 years as a practicing attorney in this area, I can tell you firsthand that these changes are badly needed. Now, let's start off. I appreciate each and every one of you for meeting with me to discuss the merits of 308. I am taking amendments that are included in your report and in the analysis to reduce the homestead exemption considerably and to reinstate or continue with the tiered system that they have. Now, most people that file for bankruptcy never had much money to begin with. We've had some changes in the Bankruptcy Act from 2005. And from 2005 to 2010, 73% of the filers earned $40,000 or less. And nearly 40% earn less than $20,000. Let me say that again. 40% of the people that are going into bankruptcy court now earn $20,000 or less. Most of the filers are married, and surprisingly, most of them are trying to support a family, and they're working. Now, despite being low income, a majority of these filers, as I said, are working at the time. They just don't make enough money to dig themselves out of the debt that they have, and often just to make the regular payments that they have in everyday life, ongoing expenses. So the homestead exemption amounts in SB 308 will still not protect many of the people in my area, in the Bay Area, in San Diego, in Los Angeles, in Santa Cruz, in San Francisco, but it can be a lifesaver for some of the folks in an average home in some of our towns in the eastern part of the state. Now, let me affirmatively address some of the inaccurate assertions that the opposition has brought up about increasing the homestead exemption and is somehow going to increase this ability for some devious debtors to dump money into their home before they file bankruptcy. And again, it's very important for you to understand the changes in the federal level that went into effect in 2006 that really protect this type of behavior. First, a person is required to pass a means test to filing into bankruptcy. 10 years ago, 15 years ago, it's possible that some millionaire willy-nilly walked into bankruptcy court. But now, if you make too much money, and that's at $42,000 in Alameda County where I practice, you're not eligible to file bankruptcy on the first brush. You have to go through a means test to see if your expenses are such. The trustees, you'll hear from a Chapter 7 trustee who is a liquidator. That's what their job is, to liquidate it. But between the trustees, the United States trustee, and the judges, we have protections. Second, a debtor in bankruptcy must completely open up their financial life. They turn over all their property to the estate, so the trustee controls all that. The trustees have the authority to claw back any transactions or transfers that were made prior to the filing. Even if a debtor paid down some of their debt before bankruptcy, the trustee can undo that. And third, the code is very clear about fraudulent transfers. This suggestion that people are going to fraudulently transfer money into their homestead or hide assets, the trustees not only can undo that and claw back the money, but they can deny the debtor a discharge in bankruptcy forever. So whatever bills that they listed on that petition, they will never be discharged in bankruptcy. And on top of it, they get to go to jail because that's a federal crime. So this landscape that's being created, that these people that go into bankruptcy are somehow rich and they're somehow going to juice the system, is just not true. I have with me in support of the bill the distinguished former past president of the National Association of Consumer Bankruptcies, Ike Schulman, and Michael Malter from the law firm of Bender and Malter.
Yes, thank you, Senator Wachowski, and thank you, Chairman Stone, members of the committee.
Please.
Yes, I'm a consumer bankruptcy lawyer. I've been practicing in San Jose. I'm in my 30th year. I'm here on behalf of our organization to strongly support SB 308. As Senator Wachowski has said, the bill makes some badly needed changes The first one that I want to talk about is the increase in the homestead exemption. With the amended version that retains the tiers, that brings the California homesteads up a little bit closer to what is a meaningful number for people to protect the value of their home. In 1975, 40 years ago, the value of the homestead exemption for Californians at the middle tier was $45,000. The average cost of a house then was $41,000. Over the last 40 years, we've come to a point where the homestead exemption for the middle tier is less than 1/4 of the cost of the average house in the state. You can contrast that with states all over the country with vastly greater homesteads, especially in relation to values of homes. Just go next door to Nevada. The average cost of a house is a little under $200,000. Their homestead exemption is $550,000. I could cite Rhode Island, a dozen states where the housing costs are far lower than California that have greater home protection. So that's badly needed. I wanted to take a minute also and talk about who's filing bankruptcy. How important is this to the California economy? In the calendar year that ended 1 year ago today, June 30th, 14, the prior year had about 115,000 bankruptcy cases filed in our state under Chapters 7 and 13. That means out of 115,000 cases, it's likely that represents about 170,000 adults when you take into account those that were married. Add to that their children. Bankruptcy has an enormous impact on helping people in our state. Who's filing bankruptcy? The folks that come into our offices are fencing contractors, daycare providers, workers for local government, people that have gotten jobs at temp services. You name it. The best way I can describe it is they're people that fall into the picture of the struggling middle class that's disappearing in America today, which I think we all know is a national issue. It's big in this state as well. In addition to the homestead change, this bill makes many changes that will help people that don't own homes. For example, it helps protect people who have car loans, filing Chapter 7. The current law says that in many cases, even though they're current on their car payments and insurance, the car can be picked up after their Chapter 7. Some car lenders are doing that. Senator Wachowski's bill fixes that. It fixes the situation where people who use the Section 704 exemptions under the Code of Civil Procedure who have a home with some equity, if you're self-employed today, the law discriminates against you. You can protect zero cash. So even if you have a home and you're a gardener and you collect your money at the end of each month, your receivables are not exempt. This bill creates for the first time a modest $5,000 grub stake for people in that situation. Right now they're discriminated against. Wage earners can protect cash when they have the homestead. Business people, self-employed, don't get that exemption. The bill has a number of other modest changes. One more I'll mention. It takes away the requirement for separated spouses to get a waiver from the non-filing spouse in circumstances where they want to claim the Section 703 exemptions. The 703 exemptions are largely used by people of more modest means, even among debtors. They don't own a house. They might have an $8,000 car, a couple $1,000s in the bank, some basic household goods. If they can't reach their non-filing spouse because they left 15 years ago or they're uncooperative, they're ineligible to use that set of exemptions, and they face liquidation of some of these assets. Fixes that. Thank you.
Thank you. Your next witness, please.